Now, it's been a busy week in the courts with high-profile cases, and some were not short of drama. One of those is the Ramaphosa Zuma matter in the High Court in Johannesburg. Things got heated when Jacob Zuma's lawyer, advocate Dali Mpofu, claimed the National Prosecuting Authority acted in a disgraceful manner when it released a statement of support for advocate Billy Downer. Mpofu at one point was warned to tone down his language. President Cyril Ramaphosa is in court to invalidate Zuma's private prosecution attempt. Zuma is accusing Ramaphosa of being an accessory after the fact. It's related to a matter between the former president, state prosecutor Billy Downer, and journalist Karen Moore. Let's speak to Judges Matter researcher Mbekezeli Benjamin. Mr. Benjamin, thank you very much for your time. Now, of course, the decorum of advocate Dali Mpofu has come into question before, in particular at the State Capture Commission of Inquiry when he was telling Minister of Public Enterprises, Pravin Gordhan, to shut up. Now a lot of people are also now asking themselves about his behavior in court this time. What do you think, though, as a Judges Matter? Do you think that he should, face some type of punity?
Good afternoon, Masejo, and good afternoon to the viewers. Well, the issue and the problem is much bigger than the individual of advocate Dali Mpofu. What we are increasingly seeing is advocates using very harsh, very combative language in court papers and in the courtroom. And this undermines the judiciary, it undermines the rule of law and the respect that people should have for the law. Because, as you know, advocates are officers of the court, so their first duty is to the court, and then to the clients, and then to their colleagues. What we're increasingly seeing is advocates not respecting this duty and using words or language that tends to undermine or harass or be undignified towards other people. And that kind of thing, we believe, is wrong, and there should be action taken against practitioners who do that, primarily by the Legal Practice Council, but also by other professional regulatory bodies like the bars that the advocates belong to.
I have to ask you this, Mr. Benjamin, and I hope you can answer. In terms of what you've seen in the High Court in Pretoria, in particular the case of the murder trial of Senzo Meyiwa, and a disbarred advocate coming into the courtroom, robed in his regalia, wanting attention from the judge and even demanding that he be seen in chamber. What else can be done when someone has been disbarred but keeps doing this?
So that's why I mentioned earlier that the problem is not individuals. We are seeing a crisis of ethics in the legal profession. And that is, the example that you mentioned now is just one of many. What should be done in that particular case is what the Legal Practice Council has announced today, which is that they will be taking legal action. They will be holding that gentleman in contempt of court, because already the courts have said he is not entitled to practice as a legal practitioner, and for him to fail to respect the court orders means that he is in contempt of court. But also in terms of the Legal Practice Act, you are not allowed to put yourself out as a legal practitioner if you are not. You must be a legal practitioner registered with the Legal Practice Council, and people, the members of the public, are entitled to actually search on the Legal Practice Council's website for your registration details. And if they can't find it, then they can't trust you, and you shouldn't hold yourself out, because it is fraudulent. In fact, it is a crime for you to hold yourself out as a legal practitioner when you are not.
And I mean, we did try. We really wanted to have the LPC on this show, especially because it was their application to have him disbarred that found him where he was at the end of last year. But I'm hoping, Mbekezeli, that you'll be able to indulge me with this question. When it comes to the Zuma prosecution and President Cyril Ramaphosa wanting to, challenge the private prosecution application, etc., by the former president, what do you say about the National Prosecuting Authority in that it gave two nolle prosequi certificates, and maybe the fact that the nolle prosequi certificates didn't limit where the former president can go is where the problem is?
Well, look, there are complexities in this case that have been dealt with both in the Johannesburg and Pietermaritzburg High Court. They relate to the conduct of the National Prosecuting Authority on the one side and some of the other people involved in this case. I can't really speak on the specific details, and I suspect it will be dealt with in the court judgment itself. And there has been some criticism of the NPA, but of course we heard yesterday from the NPA's legal representative that there are reasonable explanations for how it behaved. And that, I think, is something that the judges will have to decide in this particular case. And just again to mention the role of the judges in all of what we've spoken about so far, Masego.
Yeah.
What we saw yesterday, I think, was commendable from Judge Mudiba and the bench. They were firm. They held the lawyers to the ethical standards that we all expect them to, and we should really commend the judges, because part of the problem has been that we hadn't really seen judges being robust in how they control legal practitioners in court. And I think this week, both in the Zuma case and in the Senzo trial, we've seen the judges be much more firmer and much more robust, and we hope that it will continue well into the future.
Yeah, I think we hope so too, Mbekezeli, because these people are in certain parts of society that people look up to. Judges Matter researcher Mbekezeli Benjamin speaking to us there.